Hello, my viewers. I welcome you again to another wonderful presentation. I remain my humble self, Charles Chukwumakwoka Esquire. I wish you exceedingly well. Today, I will be talking on a topic known as breaking down property law in Nigeria. What you need to know. Today, I want us to pieces property law. When you hear about property law in Nigeria, what comes to your mind? Ask yourself this question. Now, property law in Nigeria encompasses the legal practices governing the ownership, use, and the transfer of property, both for movable and immovable property. When you are talking about property, you are talking about realty and personalty. That is personal property and real estate. Now, understanding property law in Nigeria is essential for individuals and businesses engaging in real estate transactions, and as well as the land ownership and property rights. You need to understand that all these things are very important, especially if you desire to invest in Nigerian real estate. You need to know about property law. And by this presentation, I'm going to walk you through on all you need to know about the property law in Nigeria. I will encourage you to stay tuned to the end of this video because I used to drop the important messages at the end of the video. Stay tuned. If you have not subscribed to my YouTube channel, you can do so now, and also don't forget to click on the notification bell to get notification anytime I post a video. I'm making a content on property law practice in Nigeria, all that you need to know. Now, in Nigeria, I want to let you know that property transactions is something that you will surely encounter in different levels. Whether you are buying a property, whether you are leasing a property, whether you are mortgaging a property, you must surely come in contact with this. And note that when you are dealing with property law, two things will come to your mind. Number one is movable property and immovable property. You need to know that properties are categorized into this form. Immovable properties are what we know as real estate. When you hear somebody saying real estate lawyer, it means that that person specializes in land and anything attached to the land. Realty, personal property like hotels, movable cars, assets, movable assets you can think of. The same way they have intellectual property. But today we are talking about movable and immovable property. Very important that you know all these things. And this movable property, just like I mentioned, they are like furnitures, fixtures that you can move, vehicles, equipment, something you can easily remove and move it from one place to the other. Immovable properties are like buildings, fixtures that are attached to the building. And now, it has its own law guarding that, which is major Land Use Act in Nigeria. Very important that you know that various statutory laws and customary laws govern and regulate the acquisition and enjoyment of properties in Nigeria. Before you transfer a property from one person to another, you must have to observe some laws. And these transactions ranges from either lease, sale, purchase, gift, mortgage, and so on and so forth. Like charges, you need to know all this thing. Now, what are the sources of property law in Nigeria? Now, the sources of property laws in Nigeria are customary laws. Number one is customary law. laws of our land, laws of our custom, like in the olden days wey we used to share land among ourselves, among our family land ownership, land of inheritance, all those things. That's is being regulated by the customary law, the being presided by the kings maker, the leaders of the community, different kingdom, different leadership style, different tenure system. So the next one is the next source of the property law is case laws. Case laws are the cases from court, whether receive English laws or whether statutory laws made in Nigeria, or case laws. Case laws are known as laws adjudicated by the judiciary, and decisions has been made. So when decision has been made, you look at those things. Those are things that serve as a precedent to Nigerian property law. Then another sources of Nigerian property law is Nigerian legislation. Laws made by the National Assembly, State House of Assembly, all these things are Nigerian legislation. So you need to know all these things. Then receive English laws, laws that our colonial masters brought to our land when they came to Nigeria. Very important that you know that. So some of them are still applicable in Nigeria, just like CA, Conveyance Act State of 1881, and so many other things still in operation. Now ownership right to land property has been entrenched in section 43 of the 1999 Constitution of the Federal Republic of Nigeria. Now I quote this: subject to provisions of this constitution, every citizen of Nigeria shall have the right to acquire and own immovable property anywhere in Nigeria. The implication of this section is that every Nigerian can acquire and own a real estate in any part of Nigeria once you're a citizen of this country. You just need to know that. So now we need to take it down to the rights. When the implication of ownership, it gives you rights to acquire and own a property, and as well as this right, you can exercise it by way of number one, right of use. You have the right to use that property as you wish, and nobody will query you. The owner has the right whether to use as personal, residential, commercial, whatever you want to use it for, and nobody will query you for that. Now you have the right to transfer the property from one person to the another. In case if you are looking for money and you don't have money to maybe to send your children to abroad, you don't have money to, maybe you need money to take some take some medication, maybe medical treatment, you need money to further your education, you need money for investment, and you want to raise this money. So many things that can make somebody to decide to sell his property. He can transfer it, and this laws as by ownership, you have the right to transfer. You have the, by way of either you are selling the property or you are leasing out the property, or by other way you are mortgaging the property. Then another right you have over this then is the right to exclude others. The owner has the right to prevent others from entering their land, and any entering without the permission is known as trespass. So when you own a land, you know that you have the right to use it without anybody interfering with it, and anybody that dares you, the person will just constitute what is known as trespass to land. Right to use and enjoy. Right to enjoy your property. You have the right to enjoy your property. You need to take note of this. When you have your property and you know that this property, you own it, you have the right to enjoy it. You can use it for agricultural purpose, you can use it for rental income, you can use it for anything you wish to do. You need to know all that. However, these ownership rights are not absolute. You need to know that. By the virtue of the Section 1 of the Land Use Act, it has been made known that the power has been vested on the state governor over the lands in the territory of that state. Now they have the power to hold that land in trust for the city, for the residents, for the people of that state. You need to understand that by that virtue of Section 1, you don't absolutely own that land. And by virtue of Section 22 of that Land Use Act again, before you say you have the statutory right of occupants of that land, you must go to the governor of the state and seek and obtain governor's consent over that land, either by way of governor consent or by way of deemed grant consent. These are the ways you can seek that. You don't have exclusive rights. Even government can as well come back and revoke by power of Section 28 of the Land Use Act. Government can revoke the right of occupants. After giving you CFO, they can revoke it. You need to understand that, so that when you know the power of governors in a property, you know that you have little you can do to control the affairs. Now, land tenure system. How to hold land in Nigeria. What are the way Nigeria operates under various tenure systems, which determines the land owned and managed and the ways they are doing that. Number one, just like as I mentioned, things that regulate that, customary land tenure system. Now, customary land tenure system is a tenure system where the traditional practice and custom overrides the operations of ownership. It provides way people can hold land and transfer from one person to other, and that's after that they have another one, statutory rights of statutory land tenure system. It's another way you can own land through the power of the Land Use Act, just like I mentioned above. Then another way is freehold and leasehold. You know, by virtue of that Land Use Act, what we have in Nigeria now is now a leasehold interest, because that interest is what you have for 99 years and it's not absolute, although the first year of the first right of occupants has not expired, and nobody knows the fate of that after the 99 years yet. But there is nothing like freehold again. But what we know as freehold these days, not absolutely freehold, is maybe a land that is not under government acquisition. People call it free land and freehold but in the legal sense, it's actually not a freehold. A freehold is where you own a land for perpetuity. So perpetual ownership, perpetuity is what gives you a freehold. Now, leasehold is a temporary ownership for a specific period of time where there is a reversionary interest moving that will take the land back to the original owner. Now, when you understand this thing, you know that when you own a land, you need to perfect your title document. I always tell people, perfect your title document so that you will be able to have rights to occupy that thing and let it be valued. Now, transfer of property. The transfer of property in Nigeria involves several legal processes, including one, sale and purchase. Are you buying? Are you selling? If you want to buy, you want to sell, either you are not buying, you are not selling. This is a process of transfer of ownership of land. Either you buy or you sell. These ways you transfer legal ownership by way of contract of sale and deed of assignment. You need to understand that. That's where you can actually convey legal interest. If you have a land and you don't have deed of assignment for that land, please go and get it. Not receipt. Receipt is not a title document. Not a survey plan. Survey plan is not a title document. Like some people, when they call me, I have land there, so I bought the land, I want to do CO. What do you have? I have the receipt and survey. You don't have a title document. Go and get title document first. It's very important too. Very important. Please don't underestimate that. Another way of transferring of a property interest is leasehold. Lease, by way of lease agreements, tenancy agreements, lease agreements. Just like tenants, the difference between tenancy and lease is duration. Below 3 years is tenancy. From 3 years and above is leasehold. So when you want to lease out property to, then you now have what is called lessor and lessee. Then when you want to transfer property, you have assignor, assignee, vendor, purchaser. So those are the things. So you need to know all these things. Then when another way to transfer interest in land is mortgage, legal mortgage, or charge by deed by way of legal mortgage. So all these things are a way of giving the property and the having interest on another person. The interest of the property is falling on another person while you are in possession. You are in possession of the property, but legal interest is on another person. So it's way of mortgage. When you collect loan from bank to buy a property, they will do what is called legal mortgage, where they will make so that they will have the power to sell that property. They will foreclose it at any point in time when you disappoint them. So because they don't want stories. So all these things are things you need to understand the way. Then the other way that you can transfer that is by way of gifts. Gift, when you want to give somebody. If somebody say he want to give you land, please ask for deed of gift. Ask for deed of gift. I want to give you, for instance, someone gave one of my client property for help taking care of him for old age. At the end of the day, when the person died, the children of the deceased wake up and they say, what are you talking about? Where is your deed of gift? Unfortunately, there was no deed of gift and there was no execution. And my dear, that's it. That was the end of it too. At the end of the day, how do you prove most of those things? Very difficult. Deed of assent, all these things are very important. So, and note that when somebody dies, before he can actually administer the estate of that deceased person, he must go for grant of probate or letter of administration, depending on whether the person died with a will or not. So you need to understand all these things. Please don't make mistake when you want to buy property. Please consult a lawyer. Consult a lawyer. If you have not subscribed to my YouTube channel, please kindly do so. And you can also follow me on any of my social media channels. I always do my presentation and I educate people, enlighten people in what they need to know when they want to invest in property. My audience are property investors, property developers, landlords, anyone interested in property. So take note of that. I always continue to guide you and make sure that you don't make mistakes. Thank you so much and I wish you all the best. Thank you for watching and stay tuned for the next video that I'm going to present. It's going to be a very wonderful one. Bye for now.